Hello, beautiful humans. Thank you so much for being patient with me. Thank you. If you are still here, thank you. I apologize. I tried really hard to reschedule this live, and I tried to get it so that you guys were aware that I was not going to be on here until later, and I could not get it to take in the Wi-Fi situation I was in. So I had to totally change locations. I am now in a location where I have some Wi-Fi. It's not the best Wi-Fi, but I just wanted to let you know that I am here, and thank you so much. I really, really tried. I really tried to get it so that I could tell you guys that I was late, and I just could not make it update in the Wi-Fi. So I apologize. Thank you for being patient. Thank you for still being here. And thank you so much to Irish Jen, my wonderful, incredible mod. I really, really appreciate everything that you're doing. Thank you. It has been a crazy day. I got up at 4 o'clock Texas time this morning. I caught a plane. My plane left around 6 o'clock, and I got into Phoenix around 6:30 Phoenix time. And so I had a little time to get settled and get down to the courthouse to figure out what was going on this morning. And I met up with Tom Evans, who some of you will know from Lori's first trial. He's juror number 18 on Lori's first trial. And I was able to spend some time with Tom and his wife, Susan, which I was really, really excited about. And yes, it's weird. The wall art matches my shirt. I did not plan it. I have no idea how that happened. I was on the local news this evening just for like about this long. They interviewed me for about 10 minutes, and about this much of it got on the local news, but it's all good. I'm grateful to be getting the message out there about the things that I love to talk about, which is mental health, healing, figuring out how we got to this place so that we don't ever get here again. So it was really lovely. What a wild day it was in court today. First of all, court was supposed to start at 10:30, which I'm sure it did, but I was in the wrong courtroom. I remember them saying that they were moving everything to the South Tower, but when you get to the courthouse and you check the docket for the day, it tells you the courtroom where everything is. So I went to Judge Boreski's original courtroom, which it was kind of cool to see that in person after having seen it on TV. And I sat there with Tom and his wife there for a little while, and then realized, it was after 10:30. I was like, we're probably in the wrong place. But luckily, there was a reporter. She was one of the ones who interviewed me for the local news. She was there behind me. Her name was Ashley. And she got in touch with one of her people who let her know that it had been moved to a different venue. And I do remember them saying that they were moving it to a larger venue, but even when we got there, that was the wrong courtroom. So it was something completely different. So it was not Justin Lum, but I did see Justin Lum. As soon as I got into the regular courtroom, the correct courtroom, I saw Justin Lum right up there in the front corner. I saw Nate Eaton. He was there. And then Lauren Mathias and her producer were there. And then behind us, there were some other reporters. There were actually a bunch of reporters, probably about 15 reporters there in the courtroom and clicking away on their keyboards, live tweeting the entire hearing, which is what I went ahead and did just so that people could see what was going on real time, or hear or read, I guess, what was going on real time in the courtroom. So the morning was relatively tame. We just were going through the electronic questionnaires. Now, if you missed the lunch live, I'll just briefly recap. They sent out 200 jury questionnaires. Only about 164-ish of them, 163 came back. That just means that probably some people just ignored their questionnaire, didn't answer it. And then we went through the process, or the judge took both sides of the attorneys through the process of striking certain potential jurors for either conflicts of interest, where they knew too much about the case, or hardship or other things. And thank you to Irish Jen, who's going to star your questions for me so I can come back to them. I want to make sure that I stay on the narrative. I still have not eaten anything, and I don't know about you guys, but I'm exhausted. It is, past 7. It's past dinner time, Texas time for sure. So I'm ready to eat some dinner and have a nice hot shower and get some good sleep tonight. But anyway, so they went through the process of disqualifying certain people. And if you go to the X feed, I went through exactly what some of those questions were. I think I may have gotten it wrong because it was question 18 that kept tripping people up. Question 18 was about people's trust of law enforcement. And do you trust a law enforcement officer if they're testifying on the stand? And so that was interesting that a lot of people got disqualified because they said they would not trust a law enforcement officer on the stand. And that's pretty important to the case, right? But the majority of the people who got disqualified, it was either for hardship or it was for the fact that they knew the case too well. And it was interesting because I think Lauren Matthias said around 70 people or so got disqualified because they knew too much about the case. That's a higher percentage than what happened in Idaho, according to her. So it was very interesting. Thanks so much, everybody. I just appreciate you being here. Thanks for hanging with me because I know this is you probably just have been sitting around here waiting forever, and I apologize for that. Shannon Porter, thank you for asking. I have a Venmo. It's at @3_verse. You can send money there, or I also have a Cash App, which I believe is, oh, thank you. Irish Jen is on the ball. Look how awesome she is. So yeah, thank you so much for posting that. Anyway, yeah, it's very strange that the law enforcement question was one that tripped people up. And then the other thing was either knowing too much about the case. Really, it was okay if they knew about the case. It was not okay if they had formed a strong opinion. And so there were some people who said they knew about the case, but they were allowed to come in for questioning, for further questioning, just so that they can make sure they know how much do you actually know about the case and have you formed a strong opinion about it. So that's really the thing. And yes, Rex is my uncle. I've been in touch with him and with Adam, and I hope to run into them or see them while they're here. I know Adam is here, but since he's on the witness list, he is not able to be in the courtroom, but he knows that I'm here. I've made contact with him and Rex, and so hopefully we'll get to see them at some point during this whole process. So the morning was relatively tame that way. Then we had a nice lunch break, and so that's right, we ended up with 52 people to question in person, and we're looking for 12 jurors and 4 alternates. I hope that 52 is enough. So far, oh, thank you, Ann Kimberly, that's so kind of you. So far, none of the witnesses on Lori's list have been subpoenaed. And this was a big part of what happened this afternoon. There was a lot that happened this afternoon. It was a lot. Like Judge Boreski went through all of these motions that have been filed, and definitely there were some fireworks in the courtroom. And so I want to play some of this for you, but I don't want to waste your time. So I guess maybe you can tell me in the chat. I know that Fox 10 Phoenix has posted the feed from this afternoon. I just want to know if you guys are willing to go through it a little bit with me. I don't necessarily want to play the whole thing because it was rather lengthy, but there were some specific parts where there were fireworks, especially from Judge Boreski, and I really would like to go through some of that with you because it was really interesting. I think we're starting to see some cracks in Lori, and I think we're starting to see some frustration, some real founded frustration from Judge Boreski. Thank you so much, McSpunky. This is very kind of you. I appreciate that. So yeah, you can ask questions here. And Carol Woodward, thank you for the super sticker. I appreciate you so much. It sounds like most people are wanting to watch the video. It looks like, okay. So that's what I'm going to do. The most significant firework for me today, I don't know, we're probably going to have to wait for the video to see that, just because there were a couple of times when Lori got really activated. And yeah, it took less than 5 hours of court for Lori to lose her cool. And the judge coming back over and over, just doubling down, saying, I'm not going to give you legal advice. I've already explained that to you 5 times. The judge lost his patience. Well, I won't say he did not lose his patience. That's the one thing I love about Judge Boreski. He is so professional. He is so calm. He explained so many things in such a rational way, but he even has his limitations. You know, he was trying so hard not to get upset about it, but it was very clear that he was frustrated with Lori. So Monica C., thank you so much for this super sticker. I appreciate it. So I'm going to go ahead and look up the video. Shoot, I always hate it when I do this, when I'm logged in. I always start my StreamYard logged into the wrong account because I have YouTube Premium on one of my accounts, but not on the other one. So Fox 10 Phoenix just streamed this. It just finished an hour ago. It is quite lengthy, but also Justin Lum is giving a lot of commentary on here. So maybe what we'll do is kind of speed through it a little bit. And that way we can get to the parts that are really important. So I'm going to go ahead and share my screen. And in the meantime, I will do my very best to answer some of your questions. It really is worth a full watch. I totally agree. It just depends on, you know, how much time you have and how much patience you have. Because there were a couple of times, guys, I'm not going to lie, in the courtroom when I really had to be careful not to outburst with my laughter or my comments. So here's probably the main thing that I want to talk about before we talk about the video. Because this was the thing that the thing that was the most anxious for me was seeing Lori, because I was a little concerned about that. I was afraid that, I don't know, I just was feeling anxious about it. Shannon, thank you so much for the Venmo. I really appreciate that. I haven't seen Lori in person in about 10 years. And I was kind of curious to know if she was going to recognize me, or if she would even look at me, or if she would give me the time of day, or if she did see me, like, is she even going to know who I am or remember me? And so the first time that we made eye contact was that in the morning, the state was having a little bit of difficulty with their technology. And oh, thank you, Barbara. I appreciate you. And so there was a little pause while they said, hey, can we work this out for just a second? Lori was kind of whispering with her co-counsel, and then she turned around to whisper to her investigator. And for just the briefest moment, we met eyes. There was not any recognition on her face when that happened at all. Like, I don't think she knew that it was me, or that I was there, or anything. So I was thinking, like, maybe that's going to be it. Maybe we're not going to get to, like, have eye contact. And so then when we broke for lunch, I kind of wanted to know, like, okay, I wanted to see what the process was, because you will note Lori was not shackled. She had no wrist restraints. She had no leg restraints. She was wearing the shock belt, I believe, today. And she was in street clothes. She was wearing a nice black blazer that fit her very well. It was a black and white checkered shirt. She had her glasses on with the red frames, and she looked very professional. She has foregone the prison curlers, and she basically, her regular waves were very visible, but she looked nice. There was no crazy makeup as before, but I didn't get a big look at her face, right? So after court was over, I wanted to know, are they going to put wrist restraints on her again before they take her out of the courtroom? How is that all going to function? So almost everybody seated around me got up and left right away when it was lunchtime. And I decided to hang back a little bit because, one, I was curious to see if we might see each other. And secondly, I just wanted to know how she was going to be escorted out of the courtroom. So I hung back, and I was standing in the gallery just looking at Lori, and I noticed the bailiff noticed me. He knew that I was looking directly at her. I had my backpack, my jacket, my hands were in my pockets, so maybe I looked a little suspicious to the bailiff. He pointed out to Lori that there was somebody looking at him. And so I think that's why she eventually made eye contact. So as she was getting up to leave, she started walking toward the door, and she looked over at me, and she saw me, but she looked away almost immediately. And then it was almost like she couldn't help but look back at me a second time. And I think that second time she knew who I was. She did not acknowledge me. We're not allowed to communicate with each other at all. That's like on placards on the walls. It's like, do not communicate with defendants. But I think there was some recognition there. I think she knows that I'm there. Because then this afternoon, when she came into the courtroom, she definitely looked my way to see if I was still there. She did not really acknowledge me at all, but she knows that I'm there. And I think she recognizes me. I think she knows who I am. So that was the part of it that I was just a little bit trepidatious about, wondering how she was going to react when she saw me and when she recognized me. Thanks, Tara, so much for the Venmo. I appreciate you. So yeah, I think she knows it's me. She knows that I'm there. And that was the only part that was giving me just a little bit of pause to think about, because I wasn't sure how she was going to react. But now that she knows that I'm here, she hasn't acknowledged me. I didn't smile at her. I didn't nod. Nothing. So that's all. It was very strange to be near her, to be that close to her, to hear her, talking. We've talked about this before, like just hearing her talk in court is really triggering for me. I noted on X this morning that she reverts into this baby voice when she's trying to be compliant. She would say, "No objection from the state." She reverts into that baby voice. She wants to be portrayed or seen as somebody who is nice, right? But yeah, let's get into this afternoon's motions, because the judge took the time to address every single one of the motions that have been filed from March 18th, which was the date of her last hearing, up until today. So she's filed a bunch of motions. The state filed a bunch of responses. I went over those on my channel before, but now here's the judge responding in real time to these. And I think what we're seeing is Lori has been used to getting her way with a certain set of behaviors, and she's not getting her way anymore. So that's really upsetting to her. It's very destabilizing to her. She doesn't know why this is not working anymore. And I think it activates her. It agitates her. Surviving the Survivor. Great to see you. Thank you for being here. Thank you for gifting memberships. You guys are amazing. I talked to Tom Evans today about you. And in fact, while we're here, I just want to mention Tom Evans' second book just released today, and I'm using it to hold up my computer. So I'm just going to show it to you. It's called Chad Daybell, The One Mighty and Strong, Religious Zealotry, Mormon Fundamentalism, and Murder in Idaho. So this is Tom Evans' new book. It just came out today. It's available on Amazon. All of the proceeds for his book, for the first book, go to Hope House in Idaho. All the proceeds from this book go to his grandchildren's college education fund. So I highly recommend the book. I haven't read it yet, but this is my advanced copy. It's like not even a real copy. It says not for resale all the way across the front of it. So please go out, buy the book, support Tom. He is writing a third book, and that's why he's here for this particular trial. So, all right, let's get into a couple of the things. So following from the very beginning of the trial, I don't want to go all the way back through it, but I'm Lori Vallow Daybell's first cousin. We grew up together. She was a bridesmaid at my wedding. We lived together as young adults. Both Colby, who is Lori's oldest daughter, her only surviving child, and my oldest daughter are about the same age. They spent a lot of time together. The Cox family lived in San Antonio near my family for about 10 years. We spent a lot of time together. I lost touch with Lori when she was going through her divorce with Joe Ryan, which was back in the 2004, 5, 6-ish timeframe. I was in graduate school at the time. I had a lot of stuff going on. We sort of lost touch during that process. And the last time I saw Lori was probably at a family event around 10 years ago or so. And so when all of this started happening in 2019, I went over this on my Patreon live last night. I read through all the text messages that happened between me and family members when this all started unfolding. It was very shocking to me. But just a little bit about where I was at that time frame. I had been divorced less than 2 years. I was a single mom with 3 kids at home. I had just bought a house that was a fixer-upper. I was deep into my teaching career. I had so much going on professionally and personally. And I was also just finishing my intensive outpatient care for my PTSD symptoms. So I was a lot. It was a lot that was going on. And so when Charles was killed in July 11th of 2019, Lisa Galindo says, will she be allowed to call a sidebar? She can call a sidebar, but she can't go up there. Her advisory council has to go up there, I think. So while, in July, when this happened, it was sort of like this one-off horrific, horrible event that unfortunately I was not really surprised by because of Alex's prior behavior in tasing Joe Ryan, serving prison time for that. And I was, I was like, that was a horrible event. They should need to go to jail, but I didn't have any material information to add. So I was just hoping against hope that they were going to get arrested any day. And it wasn't happening. And then the kids went missing. So that's kind of where all of this started to unfold into a lot of just horrific stuff. So I went through a lot of that on my Patreon last night. It's possible I'll have time to go over it again at some point during the trial. But today I want to focus on just recapping what happened in the courtroom today and then getting some rest because I'm super, super, super exhausted. Thank you, Irish Jen, for starring these questions for me to come back to. So let's go now to the hearing itself. Let me go ahead and play this, and I'm going to play it on 2x until we get to the meaty part, if that's okay with
Defendant's
everybody.
motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy, so I object in that way as well.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Do you live in Arizona?
Oh, goodness. Okay. So basically, Lori's trying to say that Detective Coons, he's been on the witness list for a long time, right? But now what we're noticing is that he's being listed as an expert witness in firearms. Well, of course, he's had a lot of training in that way. And so he can be an expert by virtue of his training. So basically what Lori is going to argue is that he could have just taken a weekend class and become an expert. Well, that's not how it works, Lori. We know he can't just take a weekend class. So basically what the judge is going to come back and say to the state, he's going to say, look, I'm going to need a CV and I'm going to need to know what he's going to testify to. So the state has agreed to provide that to the judge, and he's going to go ahead and let Detective Coons, for the time being, testify as an expert. And there's no reason why he shouldn't. So I think most of you are saying that you prefer for the regular playback. So I'm going to use regular speed. I do want to get through this though, because there's a lot of it going back and forth. So I'm going to do my very best to get through this quickly enough so that we can, you know, so I can get something to eat and go to sleep. Maybe if we
What his
just
opinion
do.
is, and does he have a CV? Let's table that for now.
Okay, so this, you're going to hear the judge say this a lot. We're going to table that for now. So the state is going to provide a CV for Detective Coons, and the state is going to provide a basically a summary of what he's going to testify to. So I'm going to try it at like maybe 1.5-ish or so and see how that goes.
Next I have defendant's motion to disclose 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now you're aware of what they plan on introducing.
Somewhat.
Okay.
Correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information.
Yeah, so Lori basically was complaining because the state wanted to bring in some 404B evidence, which just means evidence of prior convictions. And Lori wasn't told exactly what they were going to do. And so she was complaining about that. But the judge basically says, I don't need to rule on that. You can object to it when it comes up in court. So he's going to table that one as well. No ruling on that one.
I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why. Let me just make sure I'm looking at the right one.
Yeah, so Lori basically was saying she doesn't want any of these witnesses to testify because she doesn't like what they're going to say. And she alleges that they've all been colluding with each other and talking with each
Going to
other.
offer some sort of testimony from these three witnesses that are going to talk about, would go toward the element of premeditation and or motive. So what is your objection specifically?
This was where the fireworks started.
Mine, Your Honor?
Yes.
Oh, my objection was that after.
So I kind of had to laugh at this point because the judge says, what is the defense's objection? And she sat there for like 20 seconds and didn't do anything. And then she's like, oh, my objections? You're talking to me? You're addressing me? Like, wake up, Lori. You're a lawyer now.
Interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about. None of them
I just
are-
have to call attention to this. This is a thing that Lori does when she doesn't know what to say or when she doesn't have a good argument. She will kind of talk under her breath. It's like, I don't know what they're going to be testifying about. And so she's trying to like not call attention to the fact that she has no good argument here. So I think that was pretty funny. So yeah, Irish Jen, if you want to fast forward through and find Lori's responses to Judge Boreski's questions, those are the times I want to
personal
cover for
knowledge
the
of
most part.
any kind of crime. So
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to
Thank you, Nana of 7. I appreciate you so much.
Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed.
Okay, I'm going to skip through this a little bit because we kind of know who these people are. So Serena has evidence that Lori told her that Charles was possessed. And then Kay was the beneficiary of the insurance policy. She has personal knowledge of that situation as well as what Charles was going through as far as, talking about Lori's mental state at the time. And then the third person is in fact the person that Charles was on a date with the night before the incident occurred. And according to her testimony, her statement, Charles talked the whole time about how worried he policy, for example, and these other things. So I'm going to just pass through Trina Kay's response on that so that we can so we can hear what Lori's response is then.
Is alleging as part of the motive. And she also has information relating to the victim himself. There are allegations again of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
All right. Do you want to have further argument?
That's Lori sighing.
Just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand. And then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this. And I would like them all precluded.
Okay. Well,
So she doesn't have a good argument here. She's basically just saying she thinks that they've talked to each other. She thinks that they've colluded with each other to get their story straight. But there's no evidence that that has happened. And the judge is basically going to tell her, like, if you think that they have talked with each other, then question them about that on the witness stand. He's not allowed to give her legal advice. He's not allowed to give her direction on how to direct her defense. But he is being really, really patient with her about all of this.
okay. Well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that based on the state's avowal that those 3 specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to if they're testifying to hearsay or something like that. Next I have, is there a Mr. Eaton here? Okay.
So this is the Nate Eaton.
Okay, you filed a motion over the weekend. Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant.
So this is not the court TV attorney. This is actually Nate Eaton's attorney. I believe that's what he noticed himself as when he decided to address the court.
right now, one of the things is it's different now, right? Because he's had this off the record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness?
Okay, so Lori's argument here is a really thin one. She's trying to argue that the prosecutor had a conversation with Nate in which she directed Nate not to be in court on a certain day because he was going to get served with a subpoena. Well, first of all, we have no evidence that that conversation took place. Secondly, none of Lori's witnesses have been subpoenaed yet. She hasn't even issued the subpoenas yet for her witnesses that are supposed to appear at trial, like very soon, right? So, yeah, she's getting super emotional about it because she's upset she's not getting her way.
To this trial, how does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
Sure, Lori, sure. We all believe you that that wasn't your intention to keep him out of court.
Right.
Oh, I hate these dumb commercials. I'm so sorry. Okay. So basically, Lori is trying to say that, and what she argues a little bit later is that Nate has interviewed every single witness in this case, and that he's interviewed all these law enforcement people. So he could basically say whether or not someone said something different in the courtroom than they did in their interview with him. And what the judge is going to basically tell her is that, look, you can do that on cross-examination. He's not going to give her legal advice, but he's basically trying to tell her, you can do this on cross-examination. This doesn't need to be addressed in a motion right now. It's not, her hair is not gray. It's just, I think, bad lighting. So sorry. I just every once in a while catch a question like that I just want to say the answer to if I can. So going back here, oops, going back here. Did I not push play? I did not push play. Sorry, guys.
Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory, she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
I've been watching most of the interviews and I take my own notes, so yes.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, you would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness.
Okay, so I'm just going to skip through this because basically the conclusion that the judge comes to is that if there is a a witness that comes and says something contrary to what they've previously testified to, since Lori has watched all the interviews and she's studied the transcripts, she's obviously going to know. So on cross-examination, she can come through and address that. So he's not going to exclude Nate from the courtroom. Nate is allowed to be in the courtroom. That's where we landed on that one. Okay, I'm going to skip through and get to, is it Lonnie Dworkin? That is the next thing. I believe it is. Thank you guys for being here. Thanks for helping me to recap this today. It's a lot to slog through this. I can tell this is going to be a tiring process for me. So it's all good though. I think this is good. I have no doubt that I'm in the right place. I'm right where I'm supposed to be. Okay, so fast forwarding to,
or reprinted.
there was an issue about not including witnesses, doxing information, essentially not broadcasting or reproducing their telephone numbers or email addresses if they come out during the trial. So that we're not really missing anything super, super important there.
Go to state's motion to preclude Lonnie Dworkin and preclude noticed witnesses.
So Lonnie Dworkin is the expert that Lori wants to bring in to do his own cell brite extraction, as well as to review some of the digital evidence in the case. However, she's brought him in very late, and we're going to see some fireworks coming from Lori here on this one.
Did Mr. Dworkin ever get a report prepared?
Not that the state has received.
Do you know?
So the state still hasn't received a report from Mr. Dworkin, and they were supposed to receive it on the 21st, I think. He did do the extraction already, and according to Lori, he found a discrepancy between the state's extraction and his extraction, so that's why she's trying to get this to come back in.
So, okay. Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases, and he's doing the best he could to include our case and get it done as quickly as possible, as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin, granted something pretty extraordinary happening. I offered you a continuance last time we were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful. But at this, if depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
Yeah, so Lori basically says that Lonnie Dworkin, who is going to be her expert witness, is going to sign an affidavit and send it to the state tonight. If the state receives it, they review it. They have enough time to call a rebuttal witness if there needs to be any. We don't even know if there needs to be one at this point. The judge is basically saying, like, everything is late right now. I should just throw it out completely. But depending on what he produces, we will see how that goes. So that's another one that just is going to get tabled.
The
Moving
rest of your
on.
witnesses, we've already talked about Nate Eaton.
Now they're going to talk about all of her other
I don't know if we need to
witnesses.
go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial.
And
If
she has not
they
subpoenaed
have been
anybody.
served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant to testify about, which relevant, I told you a little bit ago, means they have testimony that's not based on hearsay, that tends to make either a fact more likely or not. So why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next, we have, I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia?
Idaho.
Vicia Ita'eha is a friend of Tylee's from Hawaii, and Lori seemed to really love helping the judge pronounce that.
Is this one of the ones the state was able to get a hold of?
No, Your Honor, we did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right.
Yes, please hit the like. Thank
Did you know that your bank account is a direct reflection of your
Goodness gracious. I'm so sorry, you guys. Okay, so they're going to go through the entire witness list, and I can tell you that it is, sorry, my mind just went blank for a second. Janice, her mother, Barry, her father, Summer, her sister, Adam, her brother, and then her former bishop, as well as Lori's friend, sorry, Tylee's friend from Hawaii. And so this is a great question, THX 1138. Lori has not subpoenaed anybody. And the people that she has asked for the witness to be on the witness list have not responded to prosecutor Trina Kay's attempts to reach out to them. So what the judge is going to end up saying is that they have to be subpoenaed. They have to be interviewed by the state prior to testifying. What's the likelihood that that's going to happen for all of those people prior to trial? Now, we are starting trial at 10:30 every day, so there's some time in there for that to happen. But yes, if Vicia gets subpoenaed, she technically has to fly all the way from Hawaii. It would probably be the taxpayers of Arizona that pay for that flight, because she shouldn't have to pay for it herself. Lori's indigent, she can't pay for it. So there's that. Sorry, let me go back to the hearing.
What about Gabriel Bonilla?
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right. What about, well, why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12 on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Chislett?
I think that's a misspelling
Oh.
of her sister's name.
Okay.
That's so funny.
I think there's potentially minimal relevance for Janice Cox, her mother.
Okay.
Adam Cox is actually on the state's witness list, so we don't object to him. I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him. but I
Yeah,
did speak
so
with him.
Zachary
Seen
Cox is Adam's son. He was actually living with Janice and Barry at the time that the crime occurred, but he doesn't really have, what Trina Kay is saying is that he doesn't have information that is specifically relevant to this case.
Pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
Yeah, this was the first time that Lori really kind of went off the rails. This was the time when she really lost it, because she does not like the way that the state comes back with a good argument against what she has. This is a very good example of her short fuse. And this is basically the whole problem with Lori's arguing, is that she does not have a good argument. She doesn't have a good case. And it makes her mad when the state does. And so she takes exception to the state using the language saying that this is trial by ambush. She's trying to say the state has interviewed all these witnesses, so I can't be ambushing. But wait till you hear what Trina K comes back with, because it's very well thought out. It's very lucid. It's very intelligent.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why you're prior.
Chef's kiss to the judge for this one, explaining it to her as if she's not an attorney.
Attorneys and your current attorneys, we're asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side, but the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did, I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my
the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not
Thank
want
you,
to give
Judge.
notice to the other side, but the limit.
Wait, I don't not want to give notice to the other side. I just wanted to clarify.
Limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dworkin late in the game that they did, I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
And I shouldn't be able to represent myself because of that fact.
I didn't-
That negates my constitutional right.
I didn't say that. All right. I said
She
that
keeps
sometimes
interrupting the judge and he's not having it. And I just really love it how she's like, she talks about her incarcerated state as if it's such a hardship. And it's like, well, Lori, you were convicted. So yeah, you are in an incarcerated state for that reason and no other reason. Somebody asked, how is it that I am not, this is Justine. Thank you, Justine. How are you not laughing out loud in court, or at the very least rolling your eyes when Lori goes off? I can tell you this is what happens. I'm over here typing in and Lori starts to go off, and here's what happens. I had to really stifle my laughter a couple of times. And there were a couple of times when I caught myself, because I went, and then I just had to, it's pretty difficult. It's going to be tough. This is going to be tough. I'm trying, you guys. I'm trying hard.
sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what the relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me.
Okay, I'm going to slow this back down to regular so that you can hear this. This is her defending her dad. So this is kind of what I've suspected all along, that her dad has been giving her advice on certain things. And Lori just goes ahead and confirms it for us here.
Life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
Very relevant.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant.
Boom.
I'm trying to find out the relevancy. What,
Just you saying it's relevant doesn't make it relevant. Thank you, Judge. Thank you. Thank you. Thank you. We love you, Judge Breath.
you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry
Hey, Lala
Cox.
West.
All right.
Thank you for being
Barry
here.
Cox.
Good to see you.
It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses excluding victims' rights.
Okay, I just want to pause here for a second before we get too far away from Barry Cox, because I just want to mention a couple of things. Somebody was asking if Barry testifies, his prior convictions could come into question. And I just want people who don't know, Barry Cox is Lori's father. Yes, he was an insurance salesman. He sold life insurance. He also had a penchant, shall we say, for not paying his taxes. Barry Cox believes that the IRS is an illegal organization. He wrote a book to that effect. It's called How the American Public Can Dismantle the IRS. Unfortunately, I bought it. I'm reading it so that you don't have to. But Barry served jail time. He was sentenced to 1 year and 1 day in federal prison, and he was ordered to pay back about $300,000 in taxes that he didn't pay over his lifetime. So, in addition, later on, just probably I think as early as recent as 2016, he was reprimanded by the state of Arizona, given a cease and desist for his practice of advertising that he was an estate planner. In order to be an estate planner, you have to be an attorney. You have to have passed the bar for that. So, so yes, Barry's prior convictions and his reprimand for trying to practice law when he's not actually an attorney could come into question. And that's what I would, if I were Trina K, I would be all over that. Barry, tell me about your habit of frequenting Las Vegas. Have you ever been convicted of solicitation? Have you ever been arrested for solicitation? Have you ever served time in jail? Do you pay your taxes? You know, these are the kinds of things that can impeach a witness's character, right? And it can come in just by virtue of the fact that he is on the witness stand. We can say, you know, oh, you were an insurance salesman. Okay. Tell me about your history as an insurance salesman. Tell me about your financial habits. Tell me about your compliance with regulations. As an insurance salesman, you have to comply with regulations. As an insurance salesman, you have to be licensed by the state for that, right? So have you ever practiced law or sold insurance at a time when you didn't have a license? Have you ever done anything that would interfere with your ability to get an insurance license? All of these things, okay? So anyway, I just wanted to mention that about Barry. If Barry does come in, it's going to be colorful testimony. I don't think that he needs to be called. I hope that he's not called. I don't really want to see him. But if he does, let me just say this. If you think Lori is interesting now, and of course, we have to take all this with a grain of salt. This is the thing that I hate about this disgusting process right now, is that it's taking all of the emphasis away from getting justice for Charles. Okay. That's what frustrates me more than anything else. However, I'm going to take a little bit of enjoyment from the entertainment aspect of it, because this has been a show since 2019 and it's been awful. So I'm going to take a little bit of pleasure where I possibly can. If you take any pleasure at all in listening to Lori be defeated in her legal arguments, Lori questioning Barry on the stand, you can't write that stuff. You can't make it up. It's going to be amazing. So anyway, this does show what Charles was dealing with. Yeah, terrible. Yeah, I mean, I suppose he could plead the fifth on some of those questions if he wanted to, but anyway, I digress. I could digress for a long time on this. So, okay, moving on.
People that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
They also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the
sorry.
best way to handle this.
I'm not even showing
other
it.
than
My fault.
maybe we should take it up as we progress through the case, but
They said I'd lose my hair
Oh,
like my
goodness.
mom
Okay.
did until I.
So I should have waited until this commercial played before I explained everything about Barry. But basically, the judge is going to shut this down as well. Basically, the way that the Judge Boreski is going to leave this is that, okay, we can keep all of Lori's witnesses on the list, right? But what's going to happen is that they have to be subpoenaed and they have to submit themselves to an interview with the state before they can actually show up and be and testify on Lori's behalf. That's kind of a ways down the road. We know that the state is planning to take around 5 to 7 days to present their case in chief. And so Lori won't be presenting her case or calling any witnesses until after that happens. So it's possible that that could still be a thing. Somebody made a comment about dillweed back here, and I wanted to find it because it's one of my favorite insults. Okay, so Barbara Brown. Am I getting this? Where am I? Okay, there we go. Is Rex's sister Janice still with that dillweed berry? Sorry, he sounds like a dillweed. Yes, they're still very much together. And they deserve each other. That's all I'm going to say.
even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good
Sorry,
faith
sorry,
effort.
sorry.
I've been told both by myself and attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point. Then the state can try to, at that point, preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say.
Okay, so here's something that the camera didn't pick up. When Trina K said, when I say it's ambush by trial, it is in fact that. And Lori went, and then she made a little joke to her seat partner, her advisory council, and giggled about it. So yeah, I'm definitely tired. That is for sure. We're almost there, you guys. This is not that much longer.
4 months to try to find them. I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit, just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information, because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. Even if they submit to interviews, I may have to make a determination whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it. It's not gonna be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that. And I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we
Well,
are doing the best that we can.
Okay.
We feel sorry for you, Lori. Actually, we don't.
All right.
Okay, I'm gonna pause here. I'm gonna pause and I'm just gonna address a couple of questions that have come up. Lori Lund is asking a couple of questions that I want to address right now. She says, can you help me understand why you don't like the Cox family? Did they do something to you? And then later on, she asks, why do you dislike the Coxes so much? Why do you throw them under the bus? Did they hurt you? I don't have any beef with Adam. I don't have any beef with Summer. She apparently has beef with me. That's neither here nor there. Barry and Janice have participated in harming children on more than one occasion. I have personal knowledge of that, as well as the evidence that we've seen in this case, the inaction, and that's what this particular trial is about. It is about how they participated. Now, I realize there are some things that I can't talk about. There are some things I will not talk about. But I have observed the Cox family behaviors over the years, and I know the damage that Janice and Barry have done to their own children, as well as to other children. So while I cannot talk about the particulars, while there are some things I will not say publicly, all I can say is that when you participate in harming children and you have a pattern of doing that, that is not something that is going to endear you to me. That is actually the one thing, just about the only thing that someone can do to get them canceled from my life. So that's really all I'm going to say about it right now. And that's one of the reasons why I've been so invested in the evidence of this case, because I want to know exactly what the actions were of these people in the time before, during, and after what was happening with Charles, because this is where it all started. And it's where it could have ended if certain people would have taken certain actions. So I get snarky sometimes because it is my outlet for the frustration and anger that I feel. It's a way, my snarkiness is a way for me to healthily express my anger. And so you're probably seeing more snark from me. I'm usually a little bit more reserved and I'm a little bit more able to control it. Being here in person, I will admit, activates me a lot more than I normally am when I'm just watching it at home and I have my people around me and my comforts around me. I'm away from home. I'm away from my children. I'm away from my Samuel. I'm away from my dogs. And I'm here by myself in the Lori box. And so, yeah, my snark is going to come out a little bit more, but I do want you to understand, like, that's the reason why I dislike Janice and Barry. Don't have any beef with Summer or Adam necessarily, until evidence shows otherwise, right? But I already have the evidence on Janice and Barry, so that's why. thank you for indulging a little bit of a rant really quick. So back to the hearing.
We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay, so we can skip through a little bit of this too, because this is just the judge. This is Lori wanting the case dismissed because of confidential correspondence being revealed. And what it turned out was that the correspondence was not confidential and it was not revealed. So I don't want to put you through listening to all of that because it's really just more brain rot. So I'm going to skip through a little bit of that just for all of our collective sanity. Just trying to look through. Jen sent me some notes here. Motion to dismiss for prosecutorial misconduct. I'm confused by your timestamps, but that's okay. We'll figure it out. And more commercials. Okay, apologies, guys. We are almost there.
It is a problem. It's a problem that she took them. It's a problem that she got them from MCSO.
Okay,
It's a problem
okay.
that she read through them. It's a huge problem that she put some of them or is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of
Oh,
messages.
I'm so sorry,
between you and
guys.
him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January.
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review. If she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney, I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me.
When she started talking about the IP address, I lost it on the inside because I don't think she knows what she's talking about. I don't think she knows what an IP address is. And his IP address was not exposed in the communications that she listed in her exhibit. So I just found it pretty funny.
That when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client attorney
Well,
privilege.
not if they're not done through privileged setup the way that they were supposed to,
Wasn't a
which he
privileged
even
setup.
acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So
If you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything that warrants them getting them from MCSO in the first place.
Say MCSO one more time. I can tell you the attorneys were very uncomfortable
All right,
during
let me
this
get from the state.
exchange.
And I think that the state's motion really covers the law under this. The defendant and
Yep.
her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Durham do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number
I'm
now
not,
has.
okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is
This
he
would be-
using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How can
addresses.
you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from? They're given to you by the state?
They're right there listed on the messages
I'm just saying, where are they obtaining those from?
from your attorney's messages to you.
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so. It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from
Yay,
different IP
Judge.
addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
Been in a car accident? Here's
This
exactly.
probably was the wildest part of this hearing today. Lori definitely lost her cool. The judge got a little bit upset. I think my very favorite part was when Lori said, who's saying that these are not confidential? And the judge said, your own attorney. There were so many slam dunks in there for Judge Boreski. There's not a 6th different way to explain it. Somebody else asked a question that was important. And she keeps cutting him off. Somebody asked if it was her attorneys or the state's attorneys that were uncomfortable. It was Lori's own attorneys. Like, her attorneys were like nervously looking at each other. They were sort of shifting, really uncomfortable in their seats during this whole back and forth. And someone asked it if I was able to keep my composure. This was me the whole time. Just typing as fast as I could and trying to make sure that I got everything and trying to make sure that I didn't laugh out loud during that part. So Scott, thank you so much. I'm going to take you up on this, and I will post a picture of my pizza so you guys can see it. I definitely need some pizza after this thing is over. And yeah, the prosecutor is calm. And look, if I'm the prosecutor or the judge in this case, here's what I'm going to do to prepare for hearings with Lori. I'm going to do a little self-talk and a little mantra that says, Lori is not very smart. She's not an attorney. She doesn't know what she's talking about. Her arguments are going to be stupid. So my job is to just point out how stupid they are. That's all I have to do. It's a pretty simple job to do. I'm going to take some deep breaths. Whatever comes out of Lori's mouth is going to be unhinged. And if it's not, I'll just be pleasantly surprised. So I'm just going to talk to myself like that before I go into court and just say, yep, it's going to be ridiculous, but this is what we have to do to get justice for Charles. This is all the avenue for justice for Charles. This is what we have to go through. This is the nonsense, right? Exactly this, Cindy. All of this will endure her nonsense until we receive justice for Charles and Brandon. This is the road we have to go down. So deep breaths. Yeah, she's very disrespectful talking over the judge. And I don't think that's going to last much longer. I think Judge Boreski really has hit his limit with some of this. And we've seen some of this as well. He probably is going to go home super exhausted. And I just hope that he's got someone there to like give him a foot massage and put his slippers on for him or something like that. I just really hope he's got some good self-care going.
Other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't.
Thank you, Paisley Dreams.
Purposely sought out by the state.
Thank you, Margie Z. Thank you for this.
Dismissal isn't the appropriate sanction if there is an appropriate sanction.
Thank you, Doral. Okay, so this is the judge denying them
for violation of confidential communication.
Thank you. He denies the motion to dismiss for confidential communication being revealed. He said dismissal is not the appropriate sanction if there even is an appropriate sanction for that. So that's basically it. So dismissal for that. We're getting down to the last thing here, guys.
All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that.
Okay, so this is the very unhinged memo where Lori brought in prosecutor Trina Kay's boyfriend who was the prosecutor on the Jodi Arias case, who was voluntarily disbarred after that case. Lori brought in all of this dirt into this motion. And what I absolutely loved is neither the judge nor Trina Kay even mentioned that at all or gave it any credence whatsoever. This was just mean girl behavior on Lori's part. And I was so glad that nobody even batted an eye or gave it any sort of credence or notice whatsoever.
The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have a response. Did you get that response?
Thank you.
Ms. Daybell, did you get that response?
I did, Your Honor.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request, saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that
I just love saying, Lori's like, that's not my complaint. And judge is like, that was the first paragraph that you started with. Hello?
I'd like to take each allegation and deal with them one at a time.
I understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. Kay in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information.
I love how Rule 11 is now a verb. Lori was Rule 11'd. I think I'm going to like make a t-shirt that says, I was Rule 11'd judge. And thank you, Cindy Ranelli, for the super sticker.
You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator to go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time. I've
So
been
why
talking-
didn't you file why didn't someone file a motion back in after, December, November, January, February?
This is how to get in
My
shape
goodness,
fast.
I'm so
you
sorry.
want.
Yeah, so the judge is just going to call her out and basically say, you had all this time to file a motion on these things and you didn't. And so, again, yes, Joe Tall Chief, where is her proof? She doesn't have any proof. She's just throwing stuff at the wall, and she's basically getting them to try and prove a negative. Like, there is no evidence. We've given you everything. She's like, well, prove to me that you've given me everything. And there isn't. So there isn't any proof that the state has done anything wrong here. And Lori can't make the well thought out argument that she needs to make. And again, she's not making the legal argument match what she wants to have happen in the courtroom because she's not an attorney. She doesn't know how to do that. And I agree so much with this Nina Canadian. No one should ever criticize Tylee's behavior or her attitude. She was raised by a woman who has no sense of adult communication 100%, 100%. Judge Boreski is probably the only person that has held Lori accountable for her life. Incidentally, I was watching just a little bit of Adam and Rex's Silver Linings podcast, and one of their listeners asked, was Lori ever told no? And Adam was like, of course she was told no. My parents were pretty strict about some things. But there's a difference between telling your kids no and holding them accountable. Like, no, you can't have something is very different than you messed up and here are the consequences for that behavior, and explaining why you're receiving consequences and explaining why the natural consequences are happening to you. This is what you did. This is what happens when you do those kinds of things. So just a slight difference there.
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
It's
This
not,
is the first
but
I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through
here it comes. Here it comes.
regarding that.
Which is what?
I'm not going to give you legal advice.
The end. Boom.
All right.
Done.
Your second allegation, the prosecutorial misconduct,
Out.
we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to the defense witness, Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
Lori.
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena. So all these things come from there and we don't know who's saying it. And you're just taking her word for it like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court. And I think that she should have to be sworn in.
Well,
Okay. This is one of those times where I did actually laugh and I had to sort of stifle my laughter a little bit because I think she should be sworn in. Okay, Lori, well, just because you think that she should be sworn in, then we're going to go ahead and swear her in. We're going to make her testify to the fact she is an officer of the court. She's obligated to tell the truth in court. And yes, the judge is going to take the prosecutor's word for it because the prosecutor has proven over time that she has integrity and that she's going to follow the rule of law. So this is just welcome to Lori's world where, all of this.
you want me to just take your word for he must have gotten these things from Ms. K. Okay. Just because his motion
That
says
too.
he thinks that you're noticing him as a witness to keep him out of the courtroom. I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing.
Exactly.
Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation.
Thank you, Judge.
If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can
interviews
interview
recorded?
him. You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness. Okay.
not a witness anymore because you just precluded him?
All right. You can interview him. You can have your investigator interview him.
So even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now. Is that what you're saying?
Sure.
Wow,
Have your
Lori.
investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Thank you, Judge. Of course. Yeah, did you
All right,
guys hear that
609
little hot
motion.
mic situation where she goes, of course. Look, the judge is being so patient with her here. When you hear Judge Boreski say, all right, like that, he's done. He's ready to move on. Next thing, don't interrupt me again, Lori. I don't want to talk about this anymore, Lori. Read the room, take a cue. Yeah. Very disrespectful, and he's being so patient with her, and I don't know how long this is going to last, you guys.
The
We're almost
state's
there.
alleged
We're almost
a
done.
total of 7 felony convictions in the state of Idaho. Under Rule 609,
Yeah, so on Rule 609, we
The
actually
court
did
finds
not,
that-
we did not get to a conclusion on 609 either, because, and I'm just going to break this down so that, because there were no Lori fireworks about this, she didn't really care about this. She did kind of push back a little bit. But Rule 609 basically talks about whether or not you can talk about or bring in other convictions. And the state or the judge said that he thought they should limit it to mentioning only two of her prior convictions. And the prosecution, sorry, did I say that? Okay, I'm sorry. Let me start over. Clear. The judge said that he believes that it should be limited to only 2 prior convictions being mentioned. The state said they thought it was important to list at least 3 of her prior convictions. Lori, of course, doesn't want any of her convictions to be mentioned because she doesn't think they're relevant. Because as we know, no one was in this case, right? According to Lori. So where they landed with that is that basically they're going to have to do it. They're going to have to address it in trial when it comes up. If it's mentioned or if it's about to be mentioned, or if there's a chance that it's going to be mentioned, then Lori can object at that time. Okay. So that's finishing up with the 609. I didn't want to have to kind of like rehash that for everybody. And of course, we've got another commercial, which I will skip. And then we will get right back to it.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now.
I think this is
But
pretty much
depending
it.
on
There's
tomorrow,
one
how far we
last
get in
little
the jury
thing.
selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
Got my microphone muted. Wanted to just answer this question. So Adam will definitively be called as a witness by the state, but not Summer or Janice. That was the implication I got. Anyone else? No. Adam is a listed witness on the state's list, so he will be called by the state. Adam is also listed on Lori's witness list, but Summer and Janice are not on the state's witness list. So we don't know yet if Summer or Janice are going to be called by Lori because the judge set down 3 rules of what has to happen. They have to be subpoenaed, they have to be interviewed by the state, and a third thing, which I forgot. But all those things have to happen before she can call them as a witness. So it remains to be seen whether she's going to comply with those instructions from the judge. If she doesn't comply, she's not going to have any witnesses at all because none of her witnesses have been subpoenaed yet. So that's where we are. There was a little thing that happened right here at the very end that I want to make sure, because Lori said, one more thing, Judge. He was
or
done.
other testimony until they're released as witnesses. Anything else from the state for today?
I don't believe so, Your Honor.
All right. Anything from the defense for today?
A couple of things, Your Honor.
A couple of things.
We need to discuss the,
How the division would like the media exhibits.
What?
How the division would like the media exhibits, if we're presenting recordings or audio, individual flash drives for each exhibit. There was
Depends on how you're going to present them, but I would say, yeah, probably 1 flash drive per recording or exhibit.
and then I'm guessing 3 copies, 1 for state, 1 for.
I don't know that you need copies if you've already disclosed it to them.
Okay, I'm going to pause just to answer this question right here. Just to clarify, they're not avoiding service because Lori even said today that the subpoenas are with the service officer right now, and they're expected to be served tomorrow or the next day or whatever. So nobody's evading service so far because they actually haven't been served yet. I think she does want her family in the courtroom, and I think she does want them to testify because she knows that she can manipulate and co-opt her family members. And those are the only people that she knows she can do that for right now. And so I think she does want them there. And I think that's why she put them on the list. And I agree with this, Shannon. Charles did everything in his power to get help and try to get someone to listen. The least we can do is now listen and hear what he went through. We're late and so many people failed him. Thank you for saying that. Yeah, I know, Lisa. I actually have YouTube Premium on my other account. When I'm signed into this account where my StreamYard is, I don't. But in the future, I'm going to make sure that I remedy that by logging into my StreamYard with the same account that I have my YouTube Premium, so we won't have this problem anymore. So thank you for your patience, you guys. And Sis says I was projecting. Sorry. Yeah, I think I wouldn't want to testify, but that's just me personally.
Just tell them what it is when we're marking it, and tell the clerk what it is with the description so it's clear on the exhibit list which exhibit is what.
One more thing, Your Honor. I wanted a clarification in your minute entry dated the 25th regarding defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, one or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimal amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering because the DOs had a question about it with me this morning. So
I ordered that you don't have.
Okay. Yes, Lori. Lori's confused, guys. Okay. This is a perfect example of Lori completely misunderstanding the whole situation. Okay. The deal is that the judge said, or sorry, the sheriff, when the sheriff responded, he said, we may choose to have extra deputies in the courtroom, but the judge ordered her to wear the shock belt. So she is going to have the shock belt. What she's trying to argue now is she's trying to say, well, it sounded to me like in the motion, in the response, that is if the sheriff wanted to put extra deputies there, then I didn't have to wear the shock belt. This is just Lori projecting what she wants to believe instead of actually reading the motion. Because if you actually read the motion, it's very clear the judge is ordering her to wear the shock belt. She doesn't want the shock belt. So she's saying, hey, it kind of sounds like the sheriff is going to have extra deputies, and so I shouldn't have to wear it, ? No, Lori, you have to wear it. The judge ordered it that way. She fundamentally misunderstands things on purpose because it doesn't align with what she wants to have happen. That's important.
Don't have to wear the leg restraint, but that you do have to wear the rack belt because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
So this is a great, oh, I'm so sorry. I'm so sorry. I'll rewind and show the court. I thought I was showing it. I get discombobulated, you guys, but I'm gonna go back and show this last part. And I'll put it on regular speed because I think it's important.
You don't have to wear the leg restraint, but that you do have to wear the rack belt because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
Well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guard?
It's up to them.
Okay.
Okay. So again, this
right,
is
so-
Lori's way of, she says okay, but she doesn't really mean okay, right? She's not really accepting what the judge says. She's just like putting an end to it at this time. Okay, guys. So I am going to now address the questions that have been starred. There are not that many of them. I think I should be able to get through them pretty quickly because some of them I've already answered. Northwest, and just thank you for being here, guys. Thank you for your support. Thank you for liking. Thank you for subscribing. Thank you to all of my channel members. Thank you to my Patreon members. I just really appreciate you, and I can't even say it in words enough. Northwest says, Megan, are you going to sit on the Lori's family reserve bench? Well, there is no reserve bench for Lori's family, as I found out when I called the clerk a couple of weeks ago. They don't make any special concessions for the family of the defense. So I'm trying to sit in the family section as a cousin to Charles, even though I'm only related to him by marriage. That's what I'm going to try to do. The judge designated at the very end today, he did designate that the front row on the side behind the prosecutor's table is going to be for family, next of kin, victims, etc. The back row is going to be for reporters, news media, etc. And then there's kind of like 2 rows in the middle there that are going to be open to the public. There's a total of about 60 seats in the courtroom. So I'm thinking probably around 40 of them will be open for the general public. I think the most significant fireworks were just Lori losing her temper and also losing her argument at the same time. She just sort of started to bang on, as they say, without really anything lucid to say, without an intelligent argument. And she just, she definitely made a fool of herself. It was apparent to everyone in the courtroom. And there were some sniggers from the news media who were sitting near me, sort of snickering, a little bit of laughing under the breath at just how she is proving herself to be a fool. She definitely was spicy today. So these were all of her motions from last week. So he dismissed he denied almost every single one of her motions. There were a couple that he said we're going to have to wait and see. The judge did not reprimand her for bringing up the prosecuting attorney's personal life, but I think he sort of logged it as like, this is what we're looking forward to here. Paisley Dream said, even though technically all her motions are late, a lot of them are late, but the judge is giving her some leeway here, right? Because he does not want her to come back and say that the judge acted improperly or that there was any kind of bias or anything like that. And so, yeah, so the judge wants to treat her with kindness and respect. So anyway, there's that. Let's see. It says Lori sure was agitated and kind of rude to the judge today. Did she seem panicked to you? Yeah, it did seem that like there were a couple of times when she was panicking because she wasn't getting her way. Her normal tricks weren't working, and so that was difficult for her. Thank you, Annette Martinez. I'm proud of you for continuing to follow this, harrowing though it must be for you. It's a lot. I'm sure that when I turn off this live stream, there's going to be a huge exhale, and I'm just going to be exhausted. So I'm going to sleep. I'm going to try to sleep. The good thing is court doesn't start until 10:30 tomorrow, Phoenix time. So just plan for that when you're planning for your day. If I have any energy at all, I might do a little live tomorrow morning. What I really would prefer to do is for when court is over, I would like to go over the timing of the trial, and I'm going to do this better tomorrow. Tomorrow, there's a little clock over on the clerk's table, and where there's timekeeping. And rather than being so detailed on X, I think what I'm going to do instead is be a little more general on X and make some timestamp notes in my notebook so that when court finishes, what I'm planning to do is come back and get those timestamps queued up so that we can just talk, be concise about the things that were really important to cover and not have to worry about the other stuff. Yeah, and I think we all agreed with you here, Leah, the empty nester. Lori acted like a petulant toddler who wanted to get her way, but couldn't give any reason other than stamp her feet and whine and say, "This is not fair," basically. So court is in the South Tower. It's court 5C, I believe. I thought it was 5D, but it's 5C. Thanks, guys, for all of the love and the support. I really appreciate you. Yeah, the snotty attitude is just going to undermine her. I don't think that Adam's testimony is going to help Lori, because the entire interaction between Adam and Charles was Charles trying to get help for Lori and Adam trying to help Charles. And the whole narrative behind all of that was the fact that Lori was saying all of these crazy things, right, with her crazy beliefs. And Adam was trying to get her to snap out of it by calling the church authorities in and trying to get her temple recommend taken away. So I think, if anything, Adam's testimony is going to prove that Lori had this narrative that Charles was possessed and that the demon needed to die, basically. I only met Charles one time. I knew him through social media, basically, through seeing the posts of family members and the comments of friends and family members who commented on how much he loved Lori, on what an excellent father he was, and how he really took care of the entire Cox family, and not only financially, but with his loyalty and his love. And it sounds like at the end that Lori turned everyone against him. And I can't imagine how horrible and scary and sad that must have been for him. So Janet M.E. says, do you think Lori will go so far and then realize it's not going to be good for her and change her plea? Could this have been her plan all along? I don't think she's ever going to plead guilty to anything, ever. She's not going to admit any kind of guilt. That is just basically that she cannot admit guilt. So I don't think that she's going to enter a plea at this point. She's going to see this through all the way to the bitter end, and she's going to believe that she's going to get exonerated of all these charges. I think that's what is in her mind. Thank you for this, BFAB DJ, and thank you to everybody who donated super stickers and pizza money and all of that. I just so appreciate it so much. It really means a lot to me. Sherry says, why is she going through this process? Her and Chad are going to be exonerated and right off into the sunset. She's such a moron. I think she just knows this is her last chance to be in the spotlight. She wants to control the narrative. She doesn't want people to think she's a bad person. So she's trying to prove that she didn't do anything wrong. I think the reason Chad was not also charged is because it's very expensive to mount a defense. Chad's already serving. He's already been assigned the death penalty. I don't think it's likely that he would have got convicted in this case. And I think that's why he and both of the Melanies have not been charged. I honestly don't know the answer to this question, but I think you're probably right. Readers learn good communication skills. She must not have read very much as a child. Ellen XP says, why doesn't the state want to have Adam as a witness? He is the state's witness. Okay, so he is going to testify for the state. Carolina says, doesn't Lori realize that she's snarky to the judge who will ultimately sentence her? Well, I just don't think she's taking that into consideration. And I think she also just believes so much in the ability of her own charms that she doesn't see it as a problem to be snarky to the judge, even though he's the only one who is putting up with her BS. Late question from Justine, but does the media know you're Lori's cousin, but they're for Charles' prosecution? So I did meet some members of the media today. I did do a local interview for the local station here. I also met the CBS affiliate, and I was able to explain to them that I'm Lori's cousin, but I am here for Charles, to see justice for Charles. So I hope that they understand that, by now at this point. But I'm willing to talk to the media who are here. Sherry says, why is she going through this? Okay, sorry, I already read that one. Why do you think, sis, you should have been a detective? What do you think about Gabe B being represented by M. Ballard's LDS lawyer? Yeah, the lawyer had the same name, but he's not the same person as M. Russell Ballard. Passed away a couple of years ago, but there is an attorney whose last name is Ballard, who is an attorney for the church, who is representing the bishop. And I'm sure they're trying to get the bishop's subpoena quashed so that he doesn't have to testify, although the subpoena hasn't even been issued yet. So there's that. And then Great Laker says, didn't the judge say the airing of the trial would be half an hour after real time? That is correct. You're right. So the live feed of the trial is not going to be a live feed actually at all. And they are not going to be doing any more streaming during jury selection. So tomorrow there will be jurors in the courtroom in person answering questions. There will be no video feed of that. So tomorrow my recaps will be without any kind of video at all. And I am going to be detailed on X about that. Once the trial actually starts, which opening statements are set to start on April 7th, I'm going to do a better job of keeping time code notes so that when I do my recap at the end of the day, that it's going to just have highlights and it won't be such a long process for everybody, hopefully. Because yes, the airing of the trial is going to be a half an hour later than real time. So trial will start at 10:30 in the morning. The live feed will begin at 11, and that is Phoenix time. And then Trish asks, can Kay, as Charles' sister and a witness, be able to watch the whole trial? Yes, she can. And she's gotten that exception. So I just wanted to go back and see if I missed any questions. I don't think that I did. Again, just thank you so much for being here and thank you for your support. I am going to do as much as I can to report as much as I can. And this question, who gets to shock her? That would be the bailiff or the sheriff's deputy, whoever's in the courtroom. They're gonna get to do that. So so many wonderful faces. If you're new to the channel, welcome. I'm so glad you're here. For those of you who've been with me since the beginning of time, thank you for your support and your kindness. We're gonna see a lot more of each other in the coming weeks, and I'm just grateful for you guys being here. Lori did see me in court today. I think she did recognize me, and I am going to go order some pizza for sure. Or I've got pizza coming, actually, people bringing me stuff. So that's great. Video feeds, etc. Sorry if late, but does Lori get to ask jurors questions? Yes, she does. And that's going to be part of what's going on tomorrow. She will get to voir dire the jury and ask them questions about their exposure to the case and their prejudices, if any. So that's what I'm going to be reporting on tomorrow. I hope you guys have a wonderful evening. Please take care of yourself. Do some self-care. Please don't let Lori get into your head. Just remember, this is about justice for Charles. It is about seeking justice. It's about telling the truth. And this is about holding people accountable. Just remember, we all know people like Lori who are manipulative. Let's remind ourselves of what those behaviors look like by observing her in court, so that when we see it in other places, we'll know exactly what it is and we can call it out. Thank you so much for being here tonight. Take care, and I will see you again very soon tomorrow. I will see you tomorrow.